Hello and welcome to Barcast Audio. In this module, in this workshop, we are going to be breaking down a family law / conflicts of law essay for the bar exam. We're going to be walking through it step by step. This workshop is designed to help walk you through a family law / conflicts essay. And for our example, we're going to be working through an original family law essay, which you can get at a link in the description of this video, or it may be attached to the audio version of this lecture. This essay is drafted in the style of the Multistate Essay Exam. It is a shorter essay in that regard. It's not like something you'd probably find on the California bar or the Florida bar. Those are longer 1-hour essays. This is meant to be taken in about half an hour. I'm going to begin by reading through the question. Take special care to note to yourself any issues and facts that stick out to you as I'm reading. I suggest you read through this twice before attempting to tackle the essay itself, just to really familiarize yourself with the fact pattern. And without further ado, let's jump right into it. In 2015, Brian and Amy began living together in State X while both were students at Capital State College. Brian proposed marriage to Amy, but she refused. However, 2 months later, Amy became pregnant. Upon learning this news, Amy told Brian that she wanted to marry him before the baby was born. Brian was thrilled and told her that they were already married, quote, in the eyes of our Lord. Amy agreed with this notion. Brian and Amy did not obtain a marriage license, and they never had a formal wedding. Nonetheless, Amy started using Brian's last name even well before their daughter was born. Eventually, their daughter was born, and they named her Dawn. After Brian graduated from college and began a new job, he listed Amy as his spouse so that she could qualify for benefits through Brian's employer. The two of them also filed a joint income tax return in 2016. In April of 2017, just after Dawn's first birthday, Brian and Amy decided to separate. They had little property to divide and agreed to the disposition without incident. As part of their agreement, Brian agreed that Amy should take sole custody of Dawn, and Amy, seeking to avoid any complications from the divorce, agreed that Brian would not be responsible for any child support. Brian told Amy that no formal divorce was necessary because they had never really been married. In July 2017, Amy and Dawn moved to start a new life in State Y. Brian gave Dawn infrequent calls on her birthday, but otherwise maintained absolutely no contact with Dawn and Amy. Just a few months after moving to State Y, Amy met and fell in love with Cameron. In 2018, Amy and Cameron obtained a statewide marriage license and wed. Sometime thereafter, Cameron formed a close bond with Dawn. Dawn regarded Cameron as her father and even called him dad. In January 2022, Amy bought a lottery ticket. The ticket won a jackpot of $20 million, which was paid later that month. Shortly thereafter, Amy informed Cameron that she wanted a divorce and she intended to use her lottery winnings to launch a new life with Dawn in a distant state. She planned to break off all contact with Cameron. When Dawn learned about this, she became very upset because she continues to regard Cameron as her father. State X recognizes common law marriage. State Y formally allowed common law marriage until a statute enacted in 2021 prospectively barred the creation of new common law marriages within the state. Neither State X nor State Y is a community property state. 1. Would Brian have a claim to a share of Amy's lottery winnings? If so, on what basis would his claim be premised? 2. Assuming that Brian and Amy have a valid marriage, on what basis, if any, would Cameron have a claim to a share of Amy's lottery winnings? 3. If Amy cuts off all contact between Dawn and Cameron, would Cameron be able to obtain court-ordered visitation with Dawn? All right, so now that we've read through the essay, which issues stuck out to you? Take a moment and try to think what the issues were. I'd suggest you go back and listen to the hypo again or rewatch that section just to get in the practice of identifying the issues as we're reading through them or listening through them. It's a helpful exercise. Go back, listen right now. We'll stop for a second. Okay, first off, the first issue that should have leapt out at you is whether Brian and Amy's marriage was a common law marriage. The hypo hangs a lamp on this fact right within the first couple sentences when they have Brian mentions that he and Amy are already married in the eyes of our Lord. So now you need to ask yourself, what are the elements of a common law marriage? And what are those elements? So first off, formation of a valid common law marriage requires 3 elements. First, that the parties were living together. 2, that they agreed to be married. And 3, that they held themselves out to others as a married couple. Now remember, knowing the rule here is not enough. We need to connect the facts of the hypo with our rule statements. So the facts here have to indicate that this is the rule that applied. We need to make that connection. That is going to be where we're scoring the most of our points in our analysis. So what facts jumped out to you? Let's start with the fact that Brian and Amy lived together from at least 2015 through April of 2017, and they both agreed to be married during that time. As to element 3, it's clear that Brian and Amy held themselves out as married. Amy was listed as Brian's spouse on his employment records. He wanted her to receive his benefits as a spouse, so they held themselves out to the employer, to the State Department, as married. And it bears noting that the facts here directly tell us that State X recognizes common law marriage. So there's no statutory prohibition on this. It seems to be all good within the confines of State X. So under these facts, it would appear that the only conclusion you can reach is that Amy and Brian did have a valid common law marriage because they satisfied all 3 elements. They lived together, they agreed to be married explicitly, and they held themselves out to be married. So we have a common law marriage. That's a pretty straightforward issue. But the trickier issue to spot here is the issue of conflicts of law. Namely, because Brian and Amy formed a valid common law marriage in State X, we have to assess whether that common law marriage would be recognized by State Y, because that kind of feeds into the rest of this hypo. So this is a relatively quick point, but will make all the difference between scoring high and really scoring low on this question, because it, like I said before, this point itself feeds into the rest of the question. The general rule to remember on this second point is that generally a marriage is valid under the law of one state, where it was initially contracted to, will be valid under the law of another state, unless there is a valid or strong public policy reason for the other state to not recognize this marriage. So think of stuff like bigamy. Think of stuff like marriage to a child. Some states have more stringent laws for those. That's the kind of thing we're looking for when we say public policy considerations. And given that the facts here tell us directly that statewide previously allowed common law marriage before 2021, it doesn't seem like recognizing Amy and Brian's common law marriage will be deemed against public policy. We don't see anything that we would typically see here in terms of bigamy or a child bride. So it seems to be something that statewide would have recognized. Okay, so now we recognize that a common law marriage was entered into by Brian and Amy. We recognize that statewide would have recognized this common law marriage. Let's move now to our third issue. That is, what is the interest of Cameron in Amy's lottery winnings? Okay, so now we've recognized that we have a common law marriage between Brian and Amy. Statewide would have recognized that common law marriage in addition to State X. So what is Brian's interest in Amy's lottery winnings, if any, based on the fact that they were still technically married at the time she won the lottery? Here, it would be likely that most jurisdictions would give Brian some interest in Amy's lottery winnings because they were still married at common law at the time of her wedding. And the rule to remember here is that property that's acquired during a marriage is subject to division at divorce. Here, the facts explicitly indicate that Brian and Amy never formally divorced. That's the fact we're looking for here. They never formally divorced. In addition to this common law marriage forming, there was no formal divorce on the record. And as such, a court would likely deem that Amy remained married to Brian, and thus her lottery winnings would be considered marital property. Doesn't sound right, but it is right. That's just how the facts here break down. You have to really be paying attention. You have to really be keying in on what common law marriage is and what the facts here are telling us. Now, because of this, Brian could seek to obtain a share of those lottery winnings in a divorce action. It bears noting that most courts will seek to distribute marital property equitably. And given that Amy and Brian are now completely estranged, Brian no longer contributes whatsoever to the marital estate, and the parties haven't cohabitated or lived together in quite some time, a court would be unlikely to give Brian much of anything if they were following this equitable guideline. Nonetheless, he would probably be entitled to some share of that interest in Amy's lottery winnings. So that wraps up just the first issue of this question. Quite a mouthful, I know. But let's move on now to the second question here. What interest, if any, would Cameron then, Amy's second husband, have in Amy's winnings? So 2 issues should jump out at you immediately from this Cameron question. First off, whether Cameron and Amy could have formed a valid marriage as a result of the common law marriage that Amy was a part of in State X with Brian. And second, this is the more tricky issue to spot here. If there's no marriage between Amy and Cameron, would Cameron have an alternative means to recovery for part of Amy's lottery winnings under the putative spouse doctrine? Now, that's not as obvious, that's not as straightforward, but that's the issue you really need to spot here if you want to score maximum points. So let's run through both of these in a little bit more detail. All right, so by now we know that Amy and Brian were already married under the common law, and they never adequately divorced. So what we're really being asked here is about bigamy. I mentioned it before, and can Amy be a part of two marriages at once? The general rule to remember here is that bigamy is illegal in every state. No individual can have more than one spouse at the same time. And because of this blanket ban on bigamy, when a first marriage has not been legally terminated, a second marriage cannot have and cannot take legal effect. Here, Brian and Amy did not divorce. And under this general rule for bigamy, Amy and Cameron were never actually married. It was a void marriage. The marriage was void at the time of inception, at the time of formation, and thus Cameron would generally not be entitled to any spousal interest in Amy's lottery winnings. I know, tough luck for Cameron, a really bad break here, but that's sort of the first issue in this second subheading that we'd be doing here. So that tells us right there, off the bat, Cameron and Amy did not have a marriage. What are Cameron's other options? What are his other options? And you should immediately jump to the putative spouse doctrine. The issue here is that Cameron may be entitled to alternatively share in the proceeds of Amy's lottery winnings under the putative spouse doctrine. So what is the putative spouse doctrine? In case you forgot, the general rule to remember for this one is that the putative spouse doctrine protects the financial and property interests of a person who, 1, entered into a void or voidable marriage, and 2, believes in good faith that the marriage was valid. Remember that generally, pursuant to this doctrine, spouses that meet both these elements are entitled to the same marital property as a legal spouse, regardless of who holds title to that property. So it seems like reading through those elements, we have a one-to-one with the facts here. We can connect those facts pretty easily. So here, Cameron and Amy appear to have engaged in a void marriage, despite their good faith belief that Amy was either divorced or she was never married to Brian at all. The facts here indicate that both Amy and Cameron were entirely unaware of any defects to their marriage, further underscoring that this was a good faith basis. As such, Cameron would probably be entitled to spousal interest in Amy's lottery winnings pursuant to the putative spouse doctrine. Good news for Cameron, bad news for Amy. The putative spouse doctrine saves Cameron's interest in Amy's winnings here. This brings us to our third and final question prompt, namely whether Cameron could be able to seek court-ordered visitation with Dawn. Now, generally, this brings to mind the most commonly tested family law rule, best interest of the child. The facts here indicate that Dawn regards Cameron as her father, but ultimately this is a bit of a red herring, meant to distract you from the prevailing rule on this issue. And that is that generally parents have a fundamental constitutional right to control the upbringing of their children, and that includes decisions about whom their children receive visitation from. When it comes to visitation by a third party, such as Cameron here, third-party visitation is only allowed where the third party requesting visitation has 1, overcome the presumption that the child's parents are acting in the best interest of the child, and 2, shown that denial of visitation would pose a risk of harm to the child. Now, this is kind of a tough threshold to satisfy. Here, Dawn has lived with Cameron for 9 years, during which he has served as her surrogate father that entire period, for 9 of her 11 years being born. In fact, Dawn has explicitly stated that she calls him dad. Further, Amy has expressed an interest in cutting off all contact with Cameron. Thus, it could be argued that Amy would not be acting in the best interest of Dawn, of the child, in cutting her off completely from her only father figure in the world. And we have a fact here that explicitly states that Dawn felt devastated that she would no longer have contact with Cameron, so you could make the argument that a denial of visitation could pose a risk of harm to Dawn, as Cameron was her only father figure. That wraps up our family law essay workshop. I hope this was helpful to you. I hope it was helpful in guiding your thought process as you go through some of these family law essays. Be sure to check us out at barcastaudio.com. If you're watching this on YouTube, thanks as always for listening, and I'll talk to you soon. Bye now.